Hello. When do we talk about complicated estates? Because not all the estates are complicated. There are a lot of simple ones or relatively simple ones when everything is clear and the property is of a relatively modest value, like a house, maybe some bank accounts. The number of heirs is one, two, three, not so many. They are direct descendants of the deceased person, or maybe a wife or husband, or parents. But there is no conflict, there is no ambiguity about that. So, okay, this is the property, these are the debts, small debts usually, maybe some credit card, maybe some credit line, but not so much. These are the taxes to pay, and this is the rest to distribute to the heirs. Basically, that's it. In such a situation, usually a liquidator, even a non-professional liquidator, like one of the heirs usually, he or she doesn't need at least a significant help of a professional, like a lawyer, notary, an accountant. But when we are in the face of, of a complicated estate, then, especially when the liquidator is an unprofessional one, not consulting a lawyer, a notary, an accountant, might end up in significant problems. So, when it is advisable to consider your estate complicated and therefore to consult a professional, maybe even hire a professional to deal with your estate. First of all, and this is one of the most usual situations, among those like unpleasant, when the estate looks okay, but without like analysis, it's not clear that the estate is in fact insolvent. And if the liquidator or the heirs, even without properly designating a liquidator, start to pay some debts of the estate, like funeral taxes, something to the bank when the bank requests, like it's urgent, mortgage, hypothec, something like that. Uh, so when in such a situation, heirs, liquidators start to mix their money with the money of the estate, there might be later a claim against the property of those heirs and even a liquidator on behalf of the creditors. And though usually the heirs are not responsible to more than what they should have received by the will or from the legal devolution from the estate. In situation of this mixture, they might expose even what they had on their own to cover the debts of the estate. So that's one of the possible complications. Uh, the estate itself can have like significant complexity about its financial situation. For example, if there are corporate shares, like corporate property, and maybe the estate or the deceased person was one of the managers, maybe the president, the director, administrator of the company, because he or she had the majority share in that particular company, or several, or even a minority, but still was appointed as a CEO. But now the estate does not become that general manager. The estate only has shares, and in the meantime, some other shareholders mm, might do something which the heirs of the estate might see as hostile. They might, for example, try to sell the company or sell the shares, or there might be something in the articles of the company that, in case when one of the founders dies or leaves the company, the shares should be bought back by the other shareholders at some fixed price and so forth, and therefore uh, the liquidator, executor, the heirs might see themselves in the presence of uh, the situation when the corporate property just gets away from them, even though they might have thought that the company would be theirs, or even if they get shares of the company, the shares might not be worth anything because the real property, the assets of the company were already dilapidated or just diluted or uh, hidden somewhere and so forth. Uh, Another complicating factor when it comes to the estate is those are all examples, as you can understand. It's not a exhaustive list. Something from experience mostly, or just case law. Uh, for example, the person who now just passed away. Before that, maybe a year ago, maybe like recent years, maybe recent months or even weeks, just gave some significant part of his property, some significant amount of money, some like valuable piece of furniture or fine art or like some collectible item, a car or whatever, transferred the immovable property title to one of the heirs, or even not to one of the heirs, but to somebody. And because of that, the value of the estate diminished significantly. And one thing, if there is a like trace of some fraudulent, but what if the testator really gave, like voluntarily gave that property, that amount of money to that person? Uh, Now the heirs might see again that they were robbed, might see it as if they were robbed, or if one of them is actually the person receiving, they might try to pretend that it was just against his share in the estate and try to diminish his share by that amount. That person might disagree, so the situation will be heading to the court most probably, or at least some sort of mediation or arbitration. And who knows what will happen. And if the acting liquidator, if the heirs do not consider such a situation and just start to act as if what they think is fair is actually legal, which is not often the same thing, uh, they might find themselves in trouble. There might be a situation when liquidators do something but do not inform the heirs, so the heirs, in panic, they try to get the information, they try to go after the liquidator. And equally not unusual is the situation when the liquidator tries to get some cooperation from the heirs, to get information, to get their signatures, but out of some personal hostility or some different understanding of what should have been done, or just because those heirs are in some just different jurisdiction somewhere far away, uh, this cooperation is not provided, and the time goes on, and other heirs might go against the liquidator for dragging the liquidation process, uh, even just blaming the liquidator for either inability or even some just fraudulent attempt, while it might be that some other heirs simply just block everything because the liquidator is not like omnipotent, is not like omnipowerful, even by the will. So there are situations when the cooperation of the liquidator of the other heirs is urgent, is necessary, is indispensable. Different situations might happen. Uh, what if the testator, when he drafted the will, he was apt, he was mentally capable, but later he or she became mentally incapable, was declared so, the protection mandate was homologated, or a protection regime was open, uh, incapacity might be total or just partial, and so forth. So there was a person with a power of attorney, or even there was no just incapacity, like the incapacity itself. There was merely some vulnerability, some weakness of the person, and so forth. So there was somebody with a power of attorney. And now that same person becomes either one of the heirs or even the liquidator, but the person with the power of attorney has an obligation to render its final account to the estate. And maybe not everything is okay in that management, and maybe other heirs suspect something wrong. And if the same person is the liquidator and is obliged on the behalf of the estate to request that report from him or herself as the ex-mandatory, and either give release or not, there might be a situation of huge conflict of interest, which might even lead to a replacement of a liquidator. Or if that previous manager is now an heir, there might be a conflict between the liquidator and that heir or heirs. So there might be a conflict. And if there is no peaceful resolution, the situation might develop all the way again to the Superior Court. Um, there might be a situation when, in the will, for example, the testator specifically said that, okay, this building goes to this heir, this amount of money goes to this heir, this bank or investment account or savings account goes to this heir, while the rest goes to everyone or to this, this, and this. And then there might be again a conflict because the building might be mortgaged and there might be a creditor who would like to seize the building, or the building might be preliminarily sold before the death, and now the buyer wants the building, but the heir who sees in the will that the building should go to him or her also wants the building. And the person who has to receive a significant amount of money wants the money from the deceased account, but the account itself should go to another person, and so forth. And while at the time when the will was drafted, there would be no such a conflict, at the time when the will became valid, when the person died, there might be this kind of entanglement, I would say, which again, usually resolvable, but sometimes there is simply not enough assets to deliver everything to everyone. And then again, the estate becomes complicated. There might be minor children among the heirs, so their legal rights are exercised by their parents usually, or at least by their tutors, if appointed. And those parents or tutors might have their own interests in the estate, or they might have an interest to contest the will to the detriment of their own children, or at least those children who they have under tutorship. And again, there might be complication. Not to mention that there might be simply not so good relationship between all those people, or maybe the testator established a trust from the estate in favor of those children. So the trustee, yet another person, might be appointed. So there is a possibility that there is a liquidator, executor, potential trustee, legal tutors of the children, and if some of the children are nearing the age of majority, that might even more complicate the things, because usually liquidation goes for a year, 2, 3, depending, sometimes longer, depending on all of those complications. So somewhat in the meantime, the minor child might become a person of full age with his or her own interests and claims against the tutor for not doing something against the estate, and so forth. There might be a situation where the deceased person before the death was in the midst of some sort of litigation 1, 2, 3, because it's not a fast process. And the state technically has to continue to defend or to protect the rights. And the liquidator might be successful or not so successful in that, or maybe not so skillful as the deceased person, which again might lead to an unfavorable development of those legal cases, and then to the heirs and creditors' claims against the estate and against the liquidator for not managing it properly. And to add to all of that, rich estates, or at least not so like teeny tiny estates, nowadays often, not always, not even in most of cases, but often, uh, they have their assets in different jurisdictions, in different countries, with banks, land, immobile property, some inheritance that was given by grandparents from another country and in another country again, because it's not unusual when one estate is not liquidated, but then one of the heirs or several heirs already also died, so their estates are heirs to that estate, and they're heirs to this estate, and therefore they have interest in that estate, and so forth. And some of them might be in a different jurisdiction, so different rules, different taxation, different time limits, different requirements as to who can and who cannot be an heir. For example, in some countries, as opposed to Quebec, where you can leave everything to whoever you want. In some countries, you necessarily have to leave something to your children or to your spouse in the will, or just from the estate, I mean. Not to mention that besides that, there is a spousal claim against the estate, not because of the will, but because of the rights of the spouse and so forth. And again, there are situations, and sometimes even like blunt situations, when one person considers him or herself to be a spouse, and then there is another person who also considers him or herself to be a spouse living in some other country, when the situation is more legal than in this country, for example, and so forth. So in a situation like that, when we understand that it's a complicated estate, the advice is quite clear and evident. Consult a notary, consult a lawyer, consult an accountant, because if you do not, you might endanger yourself, put yourself in jeopardy of being personally responsible because of some almost inevitable mistakes in the process of the liquidation. Thank you, and have a nice day.